Hello everyone, welcome to the channel. So today we are going to start our next chapter in the series of Polity through MCQ series, and these MCQs are straight away based on the book M. Laxmikanth. Now before starting the chapter, I will like to give you some of the explanation part, some of the important points in this chapter, and then straight away we will move to the questions. Now, as we have seen that in part 1 of the constitution, there is mention of union territories and states. Now in this chapter we are going to study about these union territories in detail. Now as we have seen, there is article 1 of the constitution. Now article 1 mentions three categories, okay, that the territory of India comprises these three categories. What are these three categories? The first one is the Indian Union is territories of the state. Then next what comes under the Union of India is the territories that may be acquired by the India in future, and third one is the Union territories. Now this chapter is going to be specifically about the Union territories. Okay, now we have seen now about the states. Now what does that state means? That the state is a part of the federal structure. Okay, on the other hand, the second clause is about the union territory, which falls under the direct control and administration of the central government. And these union territories are also known sometimes as centrally administered states. Okay, centrally administered territories. Now what about the territories of state, union territories, and territory that may be acquired by the government of India at any time? These are the three categories that comes under article 1 of the constitution. Now the union territory, what about union territory? That these lie under direct control and administration of the central government. Now the next point is about the creation of union territories. When were these union territories made? So first of all, the first instance of a union territory was named as scheduled district. ठीक है, सबसे पहले इनका नाम था scheduled districts, and these were made in the year 1874. Okay, and in the later stages during the British India, these were known as chief commissioners provinces. Now after the independence, they were placed into category. Basically there were four categories. First one were the British provinces, second one was the area of the provinces in which the princely states led. So basically there were four categories. Out of these four categories, the union territories were placed under part C and part D. Okay, now what happened in by the State Reorganization Act of 1956 was total there were made 14 states and 6 union territories in the India. Okay, so what happened in the State Reorganization Act basically was the 7th Amendment Act was passed. Okay, so this 7th Amendment Act made 14 state and 6 union territories for India. Now let us know. So what is the basis of formation of the creation of these UTs? Some of the UTs are made for the political plus administrative convenience, such as Delhi and Chandigarh are made for political convenience. The second one is strategic importance also. Let us have a look on Andaman and Nicobar. So these acquire a very significant control over the Indian Ocean area, no? So this is also why the control of center is important in these strategic areas. Lakshadweep, this is also a important union territory in the area of Arabian Sea. And as we observe the map of India, in the eastern side there is Andaman and Nicobar Islands, and in the western side there is Lakshadweep. So strategically the central government directly controls these union territories. So by strategic importance also the union territories are made. Okay, and backward territories and areas, this is also criteria. We have seen there are four type of tribe basically in Andaman and Nicobar: San Antilles, Shonpins, Jorwe tribe. Okay, these are the tribes which reside in India. So various criteria are there for the establishment of union territories. Now let us see about the administration of union territory. So first of all, the administration of Union Territory is mentioned under Part 8 of the Constitution from articles ranging Article 239 to Article 241. Now, these Union Territories are administered by President through an administrator. Now, this administrator has three names. So, three names can be given to these administrator. In some areas, this is known as Lieutenant Governor. Now, Lieutenant Governor, you may have listened in case of Delhi, there is LG there. Okay, then there is Chief Commissioner or Administrator. Okay, so three names can be given to this administrator, that is LG. In case of Delhi, we see as an example, Chief Commissioner is there, and then there is Administrator. Okay, now the Parliament, we have seen Schedule 7. What is Schedule 7? It consists of the federal structure. How the federal structure? So the three lists of the Constitution have been mentioned, that is Union list, State list, and Concurrent list. Now, all the things that are mentioned under Schedule 7, the Parliament has power to make laws for Union territories under Schedule 7 of the Constitution. So, all the laws relating to Union territories are made by the Parliament. Now, let me tell you about the jurisdiction part now. The Bombay High Court has jurisdiction over Dadra and Nagar Haveli and Daman and Diu. So, prior 4 or 6 years before, these Dadra and Nagar Haveli and Daman and Diu, these were two separate union territories, but in past 2 to 3 years, I guess, these have been merged, and total of 8 union territories are there, and 28 states are there right now. Now, the Calcutta High Court has jurisdiction over the Andaman and Nicobar Islands, and the Madras has the jurisdiction over Puducherry. Okay. Now you have to tell me in the comment section that Lakshadweep has control. Lakshadweep, which High Court has control over Lakshadweep? Okay. I've already told you about the Madras, Andaman and Nicobar, Puducherry. Now if I talk about Daman and Diu, this comes under the jurisdiction of Bombay High Court. Okay. Chandigarh is under the Punjab and Haryana High Court. So these are some of the examples that you need to remember. Presently there are 25 high courts in India. This you can also remember. Now, there is a special case of Delhi. So you need to remember this Amendment Act, that is 69th Constitutional Amendment Act, which provided for the Legislative Assembly for Delhi, and the 69th Constitutional Amendment Act provided the National Capital Territory region to the Delhi, and Delhi is governed by the LG, that is Lieutenant Governor. Okay. Now let us now start with the questions. Let us try and solve this. This is a small chapter, not very much to ponder about this, ponder about anything in this chapter. So let's start with the questions now. An administrator of a union territory is an agent of the president and not the head of a state like governor. Yes. So governor is there in the states and he is the executive head of the state. It means what? That all the executive decisions are taken in the states on the name of the governor. Though on the other hand, there is an administrator in the case of union territories, which is appointed by the president. So the administrator acts as an agent of the president. The first statement is absolutely true. We have not read anywhere that all the executive decisions of the union territory are taken on his name. Why? Because the central government has direct responsibility to administer and control the union territories. Okay. Next is the parliament can make laws on any subject of the three lists for the union territory. This is also absolutely true. All the list that is union, state and concurrent list that is mentioned under Schedule 7 of the Constitution, all the decisions regarding the union territories are to be taken by the Parliament. So the correct answer would be both 1 and 2 says second statement are true. Now, the president can make regulation for the peace, progress and good government of. So if you remember the president chapter, when I was teaching you the chapter of president, then I told you in the legislative functions that the president, not legislative but executive functions, that the president has the responsibility for the good governance for Andaman and Nicobar, Lakshadweep and Dadra and Nagar Haveli and Daman and Diu. So these four were the union territories regarding which the president has special responsibility to make regulation for the peace, progress and development. So Chandigarh was not an option there. So these are the three places regarding which the president has responsibility. So the correct answer would be 1, 2, 3 and 4. If you haven't watched that president lecture, do watch it. Now the things we are going to study from today onwards, they have linkage, they have proper linkage with whatever I have taught you before. So I would recommend you to watch the earlier lectures first and then solve these questions. Now let us see the third one. What is the third statement? Which of the following is correct regarding the union territories? Now Article 239 to Article 241 contains provisions regarding the union territories. Absolutely true. Part 8 of the Constitution deal with the union territories. Yes, absolutely true. Third is Part 7 of the Constitution deals with the union territory. No, the statement is wrong. Why it is wrong? Because the Part 7 consisted of the union territories that were added in Part B and Part C of the earlier to the State Reorganization Act of 1956. I already told you that the union territories were classified in 4 parts, out of which Part B and C included these union territories. So Part 7 was done away by the 7th Amendment Act, okay, of 1956. So this part has been omitted from this part has been removed from the Constitution of India. So by this technique also directly we can eliminate the third statement, and we know that the first statement is true and second is true. So B will automatically be our correct answer. Okay. So B is the right answer to this question. Now let us see the next question, that is question number 4. Which one of the following Constitutional Amendment Act provides a special category status to the Union Territory of Delhi and redesignated in the National Territory of Delhi, that is NCR. Okay. Now this was the 69th Amendment Act and the article specific to this is 239A. If I talk about Puducherry, so special provisions has been made regarding Puducherry under article 239AA. Okay? And both Delhi and Puducherry are the only union territory to have a state legislative assembly. Okay, so for this question the correct answer would be D. Now let us see the next question. Andaman and Nicobar comes under the jurisdiction of Calcutta High Court. Dadra and Nagar Haveli comes under the jurisdiction of Bombay High Court. Lakshadweep comes under the jurisdiction of Kerala High Court, and Puducherry comes under the purview of the Madras High Court. So what is the correct sequence here? The correct sequence is 4152. Okay. Now next is question number 6. Part C and Part D states were constituted as union territories by the, I already told you the act, that is the 7th Constitutional Amendment Act of 1956. This I have already explained you in the explanation part. You just need to know the constitutional amendment, that the 7th Constitutional Amendment is related to the union territories. Okay. Now I would request you one thing, although I don't request you for anything much. I have been teaching you from since the last 1 or 2 months. Since the last 1 month I have been teaching you this polity lectures. So kindly like the lecture, okay? And if you feel, you can just suggest, comment in this video and just let me know how, if you are liking this series or not. So kindly do this. It keeps me motivating to just prepare more content. So I would recommend you, I would like you to just like and comment, so that I know that you all are grasping whatever I teach here. Now, which of the following are the reasons for the creation of union territories? So I already told you, special treatment for the tribal people. We can give an example of Andaman and Nicobar here. Okay, cultural distinctiveness, yes, this is also a fact. Strategic importance, again Andaman and Nicobar and Lakshadweep, these two can be put in as examples. Care of backward people, yes. Political and administrative consideration, Delhi and Chandigarh is an example. So all the statement here seems to be true. That is why C is the correct answer. Now let us see the next question, that is question number 8. Which of the following can put a union territory under the jurisdiction of a high court of the adjacent state? Now I already told you that all the powers regarding the regulation and administration of the union territories lies with the parliament. Okay, so the parliament has the power to put a union territory under the jurisdiction of a high court of the adjacent state. So the C option would be correct. Let us now see the next question. Which one of the following union territories have high courts of its own? So Puducherry comes under Madras, we know. The Chandigarh comes under the Punjab and Haryana High Court. Lakshadweep comes under the Kerala High Court. So Delhi Union Territory has a High Court of its own. So this is a good question, an observational question. So C is the correct answer. I hope you all have solved this question correctly. Next is, in case of Puducherry, the President of India can legislate by making regulations only when the parliament passes a resolution. No, I already told you that there are two union territories which has state legislative assembly of their own. First one is Delhi and second one is Puducherry. So when the assembly is suspended or dissolved, the president can legislate on any matters, and it is done by passing an ordinance, and this ordinance is passed under Article 123. Again, all of this I have explained in the precedent chapter. So C is the correct option. So I hope you are able to understand. Okay, you just need to know the name of these two union territory, that is Delhi and Puducherry. These two have legislative assembly of their own. Now let us see the next question, that is question number 11. The Constitution of India contains separate provision for the administration of acquired territories. No, this is not true. Why this is not true? Because in Article 1 there is provision, 3 clauses that I have mentioned, and in the third clause it is mentioned that the territories that may be acquired by the India in any time in future, so no separate provisions are there for the administration of acquired territories. Okay, these comes under direct responsibility of the central government. So the first statement is not correct. Let us now see the second statement. The constitutional provision for administration of union territory also apply to the acquired territory. Yes, I have told you right now, the acquired territory are also treated as union territory, and in just one case, that just one thing is common between the acquired territories and the union territories, that the parliament has sole control over it. Okay, so this is a new point that you have learned here. So second statement is true, first one is not true. So the correct answer would be B here. So with this we have finished this chapter. So thank you for watching.